Good afternoon, everyone. My name is Erin Choquette, and I'm the General Counsel for the Connecticut Paid Leave Authority. Thank you so much for having Amber and me here this afternoon with you. Amber is recording this for us, and we will also have time at the end for questions. If you have questions while I'm speaking, please put them into the Q&A function so we can keep track of them and make sure that we've answered all of them. Richard, did you want to say anything before I go ahead and share my screen?
Yeah, please. Good afternoon and welcome to the members of BNI here in Connecticut. We appreciate your time today. And this is an excellent opportunity for us as members just to connect with our state leadership on something that's become a very important issue for us. Erin will share a lot of the details. And as she mentioned, we'll have time for questions and answers afterwards. But I do want to thank Erin, Amber, and the Connecticut Paid Leave Authority for their support and just getting us this important information for our businesses. As was mentioned, this will be recorded, so if you miss something, that's okay, and we'll pass that along to the members as well. But again, thank you, Erin, very much for the time today, and let's kick this off and let's see what we can do to help our business professionals.
Terrific. I'm going to go ahead and share my screen, and
you're all set.
There we go. So as I mentioned, I am the General Counsel for the Paid Leave Authority. Prior to joining the authority in the fall, I worked at the Department of Administrative Services, which is the agency that handles all the back office functions for other state agencies. I've been an attorney for over 20 years, focusing on employment law, administrative law, as well as litigation and legislative issues as well. But FMLA has been a part of my professional life, my entire professional life. So it's really a great opportunity for me to talk with you today and to be part of the launch of the Connecticut Paid Leave program. Today we'll talk a little bit about the program itself, how it fits into the constellation of existing leave laws. Then we'll turn to look at really how the role of the employer in administering leave and how that connects with paid leave benefits. We'll talk a little bit about private plans, which is an alternative option, as well as the process for registration. And I'll share with you some resources. So as I said, if you do have questions as I go, please put them in the Q&A and then we'll address them in the second half of the hour. But the Connecticut Paid Leave Authority is a quasi-public agency. We were created by Public Act 19-25, which is the same act that created the Connecticut Paid Leave program and amended the Connecticut Fmla. The motive behind this public act was to address the gap that legislators saw between employees who needed to take time away from work because of their own serious health condition or to care for a family member, and the economic consequences of having to go without wages while they were dealing with those life events. And so the Paid Leave Authority is created to establish an employee-funded source of income replacement benefits for individuals who need to take time away from work. We see our role as in not just helping the employees, but also to help the employers, administrators, healthcare providers, everyone who's sort of involved in the life of a claim to understand what their roles are and how to fulfill them. At the Paid Leave Authority, we have several statutory mandates, including engaging in outreach and engagement, which is why we appreciate being here today, because we really want to get out in the community, make sure that we're explaining the law and how we understand it, and to hear back from employers and employees. Because it's a brand new agency, we have to stand up the agency at the same time that we're standing up the program. So we're working on the policies and procedures needed to run the program and run the agency. The statute says that the contribution rate can be no greater than 0.5%. It also allows the authority to reduce that contribution if in the future the paid leave trust is strong and the reserves are solid. We can reduce the contribution rate. But right now we're focusing on standing up the system to allow employers to remit those contributions to the authority. As I mentioned, there is this alternative private plan option for employers who wish to fulfill their obligations under the Paid Leave Act through their own private plan rather than having their employees participate in the paid leave program. And so our job is to set that up and then review applications and audit private plans. Starting in January of 2022, employees will be able to apply to us for paid leave benefits. So we are standing that up right now as well. We are in the process of selecting a third-party administrator to handle the claims administration. And we're setting up the policies and procedures so that employees will be able to start receiving benefits in just over 10 months. We have a lot to do in a very short amount of time. And so this slide sort of identifies some of the things we've been working on. In November of last year, we opened the employer registration, and we have about 2/3 of the state's employers are already registered. If you haven't registered, I'll tell you how at the end, but please register. We need you to register. One of the reasons we need you to register is because that helps us know that you know that as of January 1st, so just about 2 months ago, you were supposed to start deducting contributions from your employees' wages. And those contributions will be remitted to the authority on a quarterly basis, just the way you remit your unemployment insurance and payroll taxes. Following the lead of Department of Labor and Revenue Services, we do give a month grace period. So technically, you have to get your contributions in at the end of the quarter, but you won't be late unless you are past April or July, 1 month after the end of the quarter. We are also currently reviewing private plan applications and will continue to do so. As I mentioned, we will begin paying paid leave benefits in January. Our goal is to get the application process set up in time so that employees can start filing their applications in December for absences that will happen after January so that we won't have a delay. The very first question we always get is, who's covered by this program? Who has to participate? And I can tell you that the legislature deliberately decided that they wanted as many people as possible to be able to participate. They wanted to ensure that part-time employees, per diems, seasonals, temporaries, small businesses could all participate. And so the definition is employers who have one or more employee working in Connecticut. That includes nonprofits. It includes private sector employers with unions. It includes entities who don't even pay unemployment. They do have to participate in the Connecticut Paid Leave Program. The legislation also allows sole proprietors and self-employed individuals who want to participate themselves personally to be able to opt in. This is similar to workers' comp, where you're mandated to provide it to your employees, but you have the opportunity to participate yourself. If you choose to opt in as a self-employed individual or a business owner, you do have to stay for 3 years. There are certain entities that are not protected by this law, and that really follows the same group of entities that aren't covered by Connecticut Fmla, and that includes the federal government. It includes the state of Connecticut in part. Covered public employees, which I'll define in a minute, are part of the program. Municipalities and boards of education are excluded unless they have covered public employees, and non-public elementary or secondary schools are also excluded. I should note here that even though it's not specifically listed in the statute, other sovereign entities are not subject to Connecticut law, and so the tribal nations are not covered by our statute. I mentioned that covered public employees are part of the program, meaning we do contribute to the Paid Leave Trust and will be able to apply for benefits. Covered public employees are defined to include non-union employees of the state, so managers, appointed officials, elected officials. If you're a unionized employee of the state, you can collectively bargain to be included. They have to do so through their collective bargaining process. Municipalities and local and regional boards of education are excluded, but if they have unionized employees who collectively bargain to be included, then everyone in that particular town or board will be included, union and non-union. As I mentioned, the contributions or the obligation to begin taking the contributions started on January 1st, and the contribution rate is 0.5%. When you're determining what that 1/2 of 1% is taken from, you really look at the wages that you calculate the same way you calculate your employee's FICA obligation. So you are already doing that to your payroll. So you determine what their FICA wages are, and then you take 1/2 of 1% from that. The FMLA, or paid family medical leave contribution, does not lower your employee's taxable wages. The contributions are capped at the Social Security contribution limit, which is approximately $142,000. As we'll talk about in a little bit, the benefits are capped, and so the contributions are capped. There's sort of an equity there. And this is similar to Social Security. So if you have an employee who earns more than $142,800, you will stop taking the contributions once they hit that limit. So the employee makes the contributions. It's the employee's responsibility to pay the contribution, but the employer handles payroll. So the employer actually has to do the mechanical process of taking the deduction from the paychecks and remitting them with some very minimal wage information to the authority. We receive the contributions, we validate that wage information, and this is not payroll. This is just some, how much, who do you have on your payroll the total amount for this quarter. The contributions are paid into the Paid Leave Trust, which is a standalone state or standalone fund. It is managed by the Office of the State Treasurer, but it is not considered to be state property. It cannot be used for any purposes other than funding the benefits and the administration. It cannot be swept in any way or used for any other purposes. As I mentioned, the Connecticut Paid Leave Act is brand new, but it fits into an existing array of other related laws. We already have 2 laws in the books, the federal FMLA and the Connecticut FMLA, that provide job and protected leave to eligible employees. The federal FMLA applies to employers with 50 or more employees and has been in law since the 90s. Connecticut FMLA has also been in law since the 90s, but up until now, it's applied only to employers with 75 or more employees. Starting in January of 2022, it will apply to employers with 1 or more employees. In addition to these 2 FMLA laws, Workers' Compensation, Americans with Disabilities Act, the Pregnancy Disability Act, and the Connecticut Fair Employment Practices Act all include some job protected leave provisions. We really haven't had any laws that provide for income replacement other than workers' comp, and that only applies for covered on the job injuries. But now with the Connecticut Paid Leave Act, we do have a law that will grant eligible employees the ability to receive income replacement when they're out of work for a covered reason. Because the Connecticut FMLA changes are so significant, we really want to just take a moment to make sure employers know what's going to be happening so they can take this year to prepare. As I mentioned, the applicability will go from employers with 75 or more employees to employers with 1 or more employees. So if you're a small business, you really need to pay attention because this is something new to you. Even if you're used to Connecticut FMLA, the eligibility changes are going to be surprising. Right now, to be eligible for job protected leave, you have to work for that employer for at least 12 months and work for at least 1,000 hours in the 12 months immediately preceding leave. But in 2022, an employee can receive job protection when they take leave after working 3 months, and there won't be an hours work requirement. The amount of leave available will change. Right now, it's 16 weeks in a 24-month period for most reasons, although there's also this military caregiver leave where you can get 26 weeks of leave. In 2022, Connecticut FMLA will be up to 12 weeks in a 12-month period, which is actually similar to what you get with federal FMLA. You'll still get that 26 weeks of military caregiver leave, but the statute allows for an extra 2 weeks of leave for individuals who have a medical certification that says they're incapacitated due to pregnancy. So in that situation, an individual may be able to get 14 weeks of leave total for the year. The final big change that you should be aware of relates to your accrual policies. Right now, under the Connecticut FMLA, it says an employer may permit or require an employee to use their accrued time when they're taking leave. In 2022, this has been changed to say the employer can permit or require the employees to use accrued time, but they can't require the employee to exhaust all of their PTO. You have to let your employee hold on to at least 2 weeks of accrued leave if they choose to, instead of making them use it while they're out on FMLA. The reasons for leave under FMLA, federal and state, are the same as the reasons that you can receive income replacement benefits. And those reasons are the following: to bond with a newborn baby or a child who's been newly placed with you with adoption or foster care, to care for a family member with a serious health condition, which we call caregiver leave. Of course, you can also take leave because you need to receive treatment or recover because you have your own serious health condition. And the definition of serious health condition includes not only injuries or illnesses or surgeries, things like that. It also includes serving as an organ or bone marrow donor, as well as pregnancy. As I mentioned, there's leave that you can take called military caregiver leave. This is available to an individual who needs to take time away from work to care for a family member who is injured on active duty in the military. There's something called military qualifying exigency leave, which is available when a family member of your employee has been called to overseas active duty, and your employee needs to take some time away from work to deal with the exigent circumstances that arise, such as going to the sending off ceremony, or going to the bank, or meeting with a lawyer to make new financial or legal arrangements. In addition to these FMLA reasons, there is a law in Connecticut statutes that's called the Family Violence Leave Act that's been around for almost 10 years. And that law says employees who are directly impacted or victims of family violence can take job-protected time away from work to relocate, to go to court, or to obtain counseling or treatment. The statute says that an employee can take up to 12 unpaid days in a calendar year for these reasons. And under the Connecticut Paid Leave Act, starting in 2022, an employee could come to the authority for income replacement during those 12 days. Now, the reasons that I just listed are the reasons that you see if you look up federal FMLA. So it looks the same between federal and state FMLA, but there is one big difference, and that is the definition of family member. Under the federal FMLA and under Connecticut FMLA as it stands right now until 2022, in order to take caregiver leave, you have to show that you're taking care of your parent or your spouse, a child who is under 18, or a child who is 18 or over who has a disability that prevents them from engaging in 3 or more activities of daily living. Under the Connecticut FMLA as amended in 2022 and under the Connecticut Paid Leave Act, an employee can take caregiver leave and receive income replacement benefits, not just if they're caring for a parent or a spouse or young child, but for any son or daughter of any age, as well as a sibling, grandparent, grandchild, or an individual related to the employee by blood or affinity, when the employee shows that the close relationship with that person is the equivalent of one of those listed family relationships. Okay, so 2 points to remember here. Starting in January of 2022, an employee can come to you and say, I need to take leave because my 26-year-old daughter has to have surgery. And that will be covered. Same with their sibling or their grandparent or their grandchild. The other thing is that the definition of family is going to be broadened to include these chosen relationships. Now this, or chosen family. Now this related by affinity is new to Connecticut, but it's not new in the leave world. In fact, the federal government has used this definition for several years in connection with federal contractor sick leave, for bereavement leave, and for a number of other leave situations. Basically, we're looking for a fact-specific analysis of, is this person akin to your parent, your spouse, your child, your sibling? It's going to be really governed by the specific circumstances that the employee brings to you. And we have a few examples just to kind of help people understand what we're talking about. We're not talking about, opening up FMLA to the entire world, but we are recognizing that families don't all look like Ozzy and Nelson, Ozzie and Harriet Nelson. And so there are just different relationships now. You may have an aunt or an uncle who really stood in the role of your parent or stood in the role of your grandparent, and that would be covered. Connecticut does not recognize common law marriages, but under this new definition, if you are in a relationship with a significant other with whom you maintain a spouse-like relationship, even though you're not married, so the Goldie Hawn, Kurt Russell situation, that would be considered related by affinity. So these next few slides are going to be a little bit repetitive, but we want to make sure that you have a single place where you can see kind of the basics about FMLA, particularly understanding how federal FMLA and Connecticut FMLA interact. So the first question is, what's the length of these leave benefits? Under both federal and state FMLA, starting in 2022, an employee can get up to 12 weeks in a 12-month period for all leave reasons, except the 26 weeks in a 12-month period for military caregiver leave. The 26 weeks is total, so it's not 26 plus 12. In addition to those two situations, in Connecticut, you also have those 12 days for family violence and a potential for an extra 2 weeks of leave for your incapacity due to pregnancy. An employee could receive income replacement benefits while taking leave for up to 12 weeks in a 12-month period for all leave reasons, including military caregiver leave. As I mentioned, we also give income replacement benefits for those 12 unpaid days for family violence and for the 2 additional weeks of income replacement for incapacity during pregnancy. The eligibility requirements for each of these laws are different. And so you may have situations where you have someone who's eligible for one benefit, but not for others. To be eligible for federal FMLA, you have to show that you were employed for at least 12 months and you worked at least 1,250 hours in the 12 months immediately preceding leave. But as we've discussed, under Connecticut FMLA, starting in January, you'll be eligible for job protection once you've been employed for 3 months. For income replacement, we don't look at how long you've been employed at all. We look at how much money you've earned. As long as you've earned at least $2,325 in your highest earning quarter, when you look at the first 4 of the 5 quarters immediately preceding your leave, you may be eligible as long as you are also currently employed or you had been employed in Connecticut in the 12 weeks before you request benefits. This ability to receive income replacement benefits, even if you're not currently employed, is really a recognition of the fact that you may have employees who aren't eligible for either federal or state job protected leave, but still have to stop working because of a qualifying condition. And so in that situation, they can receive income replacement benefits from us. I do want to note that we will look at earnings from all employers. So you could have employees who work part-time jobs and they won't earn the $2,325 from each job, but if you aggregate their funds, they'll hit the eligibility requirement. Okay, so what does this mean for employers? Well, it is already true that anytime you have an employee ask for time off from work for one of those reasons I listed before, you should be thinking, is this employee eligible for some sort of statutory job protection when they take leave? And also, is this employee eligible for any income replacement? You want to ask those questions each and every time, and you need to ask both because the answers may differ. As I mentioned, you could have someone who's only eligible for federal, or maybe they're only eligible for state FMLA. If they're eligible for both federal and state, their leaves will run concurrently, meaning they'll draw down the 12 weeks at the same time. Some won't be eligible for job protection under either federal or state, but maybe a leave would be a reasonable accommodation under the ADA or Pregnancy Disability Act or CFPA. And some employees won't be eligible for job protected leave at all. The other question you have to answer is this employee eligible for income replacement? The statute says that an employee could receive benefits from the paid leave authority and their employer at the same time, but the total amount cannot exceed more than 100% of their employee's regular wages. We know that many employers provide short-term or long-term disability as a benefit to their employees. And you'll have to look at the terms of your specific policy to determine how that relates to the Connecticut paid leave benefits. Most of them will say that the employee needs to utilize their employer-provided or state-provided benefits first. They call themselves the payer of last resort. And if that's the case, your employee would apply to the paid leave authority for income replacement benefits and wouldn't access their short-term or long-term disability until they've exhausted our benefits or to supplement our benefits. If you have an employee who's out receiving workers' compensation benefits, they cannot receive income replacement from paid leave authority. That's a statutory bar. As I mentioned, you need to ask both questions at the same time because some employees may be eligible for for paid leave, but not eligible for job protection. But when I say you have to ask the question, I mean you have to think about it, but it is not your responsibility as an employer to decide if an employee is eligible for benefits from the paid leave authority. The paid leave authority will make that determination. There's one exception here, which is if you have an approved private plan, you have said that you're going to stand in the role of the paid leave authority, and you will be making the decision, you or your insurer will be making the decision about whether your employee is eligible for benefits under your private plan. As you mentioned, you may require your employees to use your employer-provided accruals. Many employers will choose to continue to do this because it provides employers with more control and does eliminate or minimize some stacking of leaves. But that will be up to you. But you do have to make sure your employees understand they are not required to exhaust those accruals while they're out on FMLA. They can keep 2 weeks. So you will have an employee come to you to ask you for job protected leave. That's going to be handled by you as the employer. The employee will come to the paid leave authority to request income replacement benefits. But the authority will validate that the reason for leave is covered and will validate that they're eligible based on their earnings. And we'll be using DOL and DRS, Department of Labor and Department of Revenue Services data to help us with those eligibility determinations. We are responsible for calculating the benefit amount, but in order to do so, we will need to communicate with you and the employee, so the employer and the employee, because we need to determine if there are any offsets based on employer-provided paid time off, and we will need to validate that the absences are occurring. And then we'll issue the benefit payments. The formula for those paid leave benefits is set forth in statute, and it really depends upon how much you earn. I do see that someone is raising their hand, but if you could put your question in the Q&A, I can address it at the end. If your employee earns less than or equal to the minimum wage times 40, the Connecticut minimum wage times 40, their benefit will be 95% of their weekly earnings. So basically what we're looking at is if they earn $480 a week or less, they'll get 95% of their wages as income replacement. If they earn more than $480 a week, they'll get that $480 plus 60% of the difference between how much they earn and the $480. However, the total weekly benefit is going to be capped at 60 times the Connecticut minimum wage. So right now that's $720. Just have a couple of examples here just to show how it works for people who like to see the math. Mike is earning $375 a week. So just a straight up 95% of $375. Deborah, on the other hand, earns $700. So we have to do that two-step process. Get the $480 plus 60% of the difference between $700 and $480 to determine that Deborah's weekly benefit will be $612. So we know that some employers will have spouses who work for you. And there are rules under both federal and state FMLA that say if the spouses both work for the same employer, they don't want everyone to be out of work at the same time. So they have to share some of their job protected leave. Under federal law, you only have to share your leave if it's for bonding or a care for your own parent. So if my husband and I work for the same company and I took 7 weeks to care for my dad when he had hip replacement, my husband would only have 5 weeks available to him if he had to care for his mother. It's just the way they made the law. Under Connecticut FMLA, it's a similar situation. You have to share for the bonding, but you also have to share if you're caring for a family member, any family member with a serious health condition. Under the Connecticut paid leave law, we're not requiring the spouses to share their entitlements to the income replacement benefits. So this is an area where you may have a situation of an employee who is out of work and is not receiving any job protection because their spouse took it all, but they still can get the income replacement. So just briefly, I want to hit on private plans. It's just on 130. Section 31-49O of the Connecticut General Statutes creates this opportunity for employers to apply to use a private plan to meet their obligations under the Connecticut Paid Leave Act. This is not an opt-out. You still have to allow your employees to receive income replacement benefits, but instead you're saying you want to manage it yourself. If you get approved to offer a private plan, you will no longer have to remit your employees' contributions to the authority, because your employees won't be coming to the authority for benefits. You are entitled to withhold a portion of your employees' wages to help fund your private plan. You can only use that money for the private plan. You cannot use it for any other purposes, and you cannot pool it with your other benefits programs. And if you do so, you are limited to the same contribution rate that the authority uses. So right now it's 0.5%, although you have the opportunity to ask for less from your employees if you have the funds to do so. Employers who are interested in the private plan option, I encourage you to go to our website, www.ctpaidleave.org, and look for the I want to apply for a private plan. We've got all of the information that you need there, including the policy documents that sets forth the policy procedure for what the plan needs to include and how to apply. It also includes some of template documents that you need to modify. There's also a link to see which insurance companies are offering Connecticut compliant private plans if you want to go for a fully insured option. Because the private plan must offer the same or better benefits as the public plan, so same amount of time, same reasons, same benefits, a short-term disability policy or a long-term disability policy is not going to cut it. You really need to have something that's tailored to the Connecticut paid family leave law. As I mentioned, it cannot cost more than the public plan, and it must cover all of your employees. Now, if you're a multi-state or multinational, it only has to cover the employees that you have working in Connecticut, but it has to include all of them. You can't have a private plan for your executive suite and then tell the manufacturing floor that you want them to participate in the public plan. Because the Connecticut paid leave program is employee funded, the legislature wanted employees to have the final say as to whether they wanted to work with the employer with a private plan or to stay in the public option. And so you have to put your proposed private plan to a vote of your employees before you apply to us. And the majority of your employees have to approve the private plan. As I mentioned, we have a number of insurance companies that have filed the paperwork necessary to offer private plans in Connecticut. There's also a self-insured option if you choose not to use an insurance policy. You can do that. Although with the self-insured option, you also have to post a surety bond in the amount of a year's worth of estimated contributions. That bond is not to fund your plan. You still have to find other sources of income or money to fund your self-insured plan. That surety bond is to ensure that your employees and the authority are protected in the event that you are not able to actually carry forward with your proposed plan and those employees end up participating in the public option. Okay, registration. Before I answer any questions, I need to really make a plug. You need to register your business. By registering, you'll create an account with ctpaidleave.org. This will enable you to make your payments at the end of the quarter, and it will make sure that we know that you know that you're supposed to be remitting those payments. If you aren't withholding your payments right now, you have a limited opportunity to catch up. The Department of Labor is authorizing employers to withhold up to 1% of your employees' pay to make those catch-ups, but that's only until the end of the second quarter of 2021. Any missed contributions after that are really the employer's responsibility to pay, and you can't take it out of your employees' paychecks. And you could be subject to additional fines or penalties if you're not compliant. So register. It's easy. The first thing you have to do is create an account with ct.gov. This is also referred to as Business One Stop or the Business Portal. This is not something specific to Connecticut Paid Leave. This is actually something that you'll have to do with any of your interactions with state government. It's relatively new, so not all agencies are requiring this yet, but over the next few years, you'll see that all agencies will tell you that you need to create credentials with ct.gov. So you go to business.ct.gov and you get your credentials. And then once you have those, you come back to ctpaidleave.org and you register your business. It takes less than 10 minutes once you have your credentials. We do know that this new law these new laws are confusing to people, and your employees might be wondering what's going on, particularly if they're paying attention to their paychecks. So we've created some information for you and for you to give to your employees, including an employee rights poster, rack cards, fact sheets, and a paycheck mailer. All of these are available on our website. They're all available in color and in black and white, and they're all available in English and Spanish. So, what do you need to know? If you forget everything else from today, these are the 4 things I would like you to remember. First, if you haven't done so, register. Go to ctpaidleave.org and register as soon as possible. Second, make sure you're doing your withholdings. If you are using a payroll provider, they should have already started processing those wage withholdings because we've been working with them for months. But it's always good to double check. Third, educate yourself and your employees. There's this whole slew of information on the website, as I showed you. There's a toolkit. There's also videos. So share that information with your employees, share those links with your employees, and come back and visit. Check out ctpaidleave.org. We update it regularly. We have FAQs that we've been adding to pretty much every month. We've been adding videos. There's all sorts of resources. If you can't find the answer to your question, you can contact us. There's a tab called Contact Us, and you can submit your question to us through that portal. And we'll get back to you either through email, or if you request it, we can set up a conference call. All right, I'm going to stop sharing my screen because I know that there are questions that are coming in.
Yeah, and Aaron, thank you very much. And before we get to the questions that were submitted, I do have just a couple, and I believe you touched on these as well. But I want to highlight that about 15% of the members within BNI are involved in the insurance industry. And so I certainly want to highlight the ability for the private plan option that they should reach out to the insurance professionals in their chapters as a first step. We always encourage that. And I think your slides show that it is possible to go either direction, whether private plan or through the state managed efforts. So I just want to highlight that because that was one of the questions that came up before your presentation, someone who could not attend if there was that private sector option. And you did cover that.
And I should point out, just before you go on, the Department of Insurance is continuing to accept declarations from providers. So that's if anyone else wants to offer a private plan to the market, they can go through Department of Insurance, and they are still accepting those.
Okay, no, that's very good to know, and I'll definitely highlight that to the folks that it affects as well. Another set of questions that came in, 3 different questions here. Do all employers need to enroll regardless of size of employer?
Yes.
One or more employees, unless you're sole proprietorship, and then you have an option either way.
Correct. And if you're a sole proprietor with employees, we consider you to be an employer. So you have to register for your employees. If you choose to participate personally for your own situation, then that's where you have the option.
Okay. The web portal talks about waiving out of the plan. How is that done, and to whom does that apply?
So that is the private plan option. So that's really the only waiver option is the private plan.
Okay. And those are the questions I received ahead of time. So Amber, I think you were going to handle the questions that were submitted online.
Yes, thank you, Richard. All right, Erin, so let's get started. So this first question is regarding short-term disability. And just to clarify, you had stated that the employee will need to exhaust the state income replacement first?
So the first answer is check your policy and see what it says. But we do know that most short-term disability policies say that they are the payer of last resort, meaning that employees have to utilize any other benefits. And so if your policy says that, then your employee would come to the paid leave authority for benefits before they would apply through the short-term disability policy.
Okay. And are these benefits taxable?
Yes, they are. We received an opinion from the Department of Revenue Services that says there is nothing in either state or federal law that excludes these benefits from tax consequences.
Okay. And if an employee is paid 100% commission, how is their benefit then calculated?
Great question. And so, as I said, we are basing our calculation of wages on the same factors that you look at when you're determining what your FICA wages are, or your wages for FICA purposes. So commission is a wage. So we would look at, you do the same exact calculation that you're already doing for your employees or for yourself for purposes of making sure you're paying your federal and state taxes.
Okay. And how would you pay these contributions quarterly? For example, this person runs their payroll through QuickBooks.
So I'm sorry, you kind of jumped out. I can't hear.
So how would you pay the contributions quarterly? The employer runs their payroll through QuickBooks.
Okay, so QuickBooks, first, make sure you've got the most up-to-date version of QuickBooks because they sent out an update in December to make sure that the QuickBooks has the opportunity for you to take and track the 0.5% deduction. Then you are able to remit those payments to the CT Paid Leave Authority directly on our website. So in that functionality, we're just finalizing testing now. I want to make sure all the money comes to the right place, doesn't get lost. But you will be able to go straight into ctpaidleave.org, and there will be a opportunity for you to remit your contributions that way. If you use a third-party payroll provider, they are busy working with us to get themselves set up, doing all the penny tests and all of that. So they will just remit directly through a batch filing. Employers have the ability to do batch filing as well if they're large enough, but most of the small employers we know just want to be able to go onto their account in ctpaidleave.org and remit that way.
Okay. And in regards for the deduction, is that pre-tax or post-tax?
So the deduction is post-tax in the sense that it does not lower an employee's taxable wages. So as you said, you're already calculating your employees' wages for purposes of determining what their FICA obligation is. So you would just take the wages that you've already calculated for that and take the 0.5% from there. So that means, for example, you don't have to impute the value of your cafeteria plan and add that into your employees' wages before you figure out their 0.5%. Cafeteria plan's out for us, just like it is for FICA, but you can't take the 0.5% and use that to lower their gross taxable wages.
Okay. And how would this affect out-of-state taxes for a person who works in Connecticut and lives in Massachusetts?
That's a great question. So our law, and actually this is similar to what you see in New York and Massachusetts and Rhode Island, we focus on where people work. So we don't really care where you live. The issue is, are you working in Connecticut? If you're working in Connecticut, then you're subject to the Connecticut Paid Leave Program and have to remit the 0.5%, even if you live in Massachusetts or New York or New Jersey or Rhode Island. If you live in Connecticut, but work in one of those other states, all of those other states have existing paid family medical leave programs. So you're most likely already contributing to those programs and you wouldn't be contributing to us.
Okay. Is pregnancy a pre-existing condition Meaning if my wife were to get pregnant and then deliver after 1/1/22, can you still claim, or would she have to have conceived in 2022? Thanks.
Interesting question. You can tell this is an insurance group because I get this a lot, but never as a pre-existing condition. So the statute says that you can receive income replacement benefits starting in January of 2022, and you have to be out on leave in January of 2022 going forward in order to receive those benefits. However, the statute also says, particularly in connection with pregnancy, that a family or parents could bond with a newborn or newly adopted child anytime within 12 months of birth or adoption. So if you have a situation where the baby is born in August, but you don't take bonding leave right then, you decide that you're going to bond with the baby come February of 2022, and that's when you want to take your bonding leave, then you could take your bonding leave under Connecticut Fmla then, and you could receive income replacement benefits from us then. You can't come back to us next year and say, oh, I took bonding leave for my baby back in August. Can I have some benefits? We don't have the ability to do that.
Okay, thank you, Erin. And can you clarify just a little bit? So is an employee being double taxed if the contribution is being taken out post-tax, and then when they receive the benefit, it's taxed again?
So Amber, I'm having a lot of trouble hearing you, so I'm just going to look on the system and see if I can figure out what the question is.
I'm sorry about that. It says if the employee is the employee being double taxed if the contribution is being taken out post-tax and then received through benefit, it's taxed again.
So I think you're asking basically, what do you mean? Why aren't you getting some tax benefit here, right? Like if it's after tax money, when you contribute, then why are the benefits taxed again? That's the way the statute is written. And we don't have control over that. I can tell you that we have heard from tax advisors that if you, certainly for the contribution part of it, if you normally do itemized deductions and you take deductions for payment of state taxes, that you could include the contributions as a state tax for that purpose. But otherwise, it's really just the way the statute was written.
Okay. All right. How do nonprofits with no W-2 staff members, only 1099 NEC, register?
So if you don't have any W-2 employees, we don't consider you to be an employer. 1099 is what you use for independent contractors. And so independent contractors are not employees for our purposes. If you are an entity that you're the owner and you want to register for yourself, you can apply as a self-employed or sole proprietor. But if you don't have employees, then we don't consider you to be an employer.
Just to follow on to that, Erin, if you have a mix of W-2s and 1099s, you would not calculate based on the 1099s whatsoever.
Correct.
Okay.
I'm assuming with an organization like yours and with your members, your members are very good and diligent about making sure that their independent contractors are true independent contractors. I'm an employment lawyer, I have to say that. But if we're talking about true independent contractors, they're not part of the program. Employees are. So we really look at, are you receiving a W-2? And I should note that corporate officers who receive W-2s are employees. And so even if they've structured their business, even if they're the owner, but they've structured their business so that they themselves are an employee receiving a W-2, we'll consider them an employee as well.
And I would imagine that it's certainly prudent that any employer speak with their accountant about how this may or may not affect their taxes and what they've got to do on the employer tax submission side.
Yes, absolutely.
Okay, thank you, Erin. All right, so if an employee has two jobs and makes more than $142,800 combined, will they get a refund of the overpayment of their contribution similar to Social Security?
Yes, they will.
Great.
And we're still figuring out the exact mechanism for that, but I think because you're working for two jobs, the refund will have to go directly to the employee. It won't go back to the employer to funnel back to you. It'll just go back to you.
Okay. And as an employer, it was mentioned that we need to set aside the funds, but it sounded like this employer would need to do that personally. She feels she cannot ask Paychex to set it up in their payroll service. Can you comment on that?
So, right. So the employer would only have to set aside funds if they have if they want to offer a self-insured plan, right? So you can continue to, so that's what I was talking about when I was saying set aside the funds, because the surety bond that you obtain is not the source of income. There's not going to be what you tap into to pay the benefits. The surety bond is held aside and is really just there in case of emergency. So that's what I was referring to when I was talking about setting aside funds. If you are an employer with an approved private plan, you are entitled to take withholdings from your employees' paychecks to help support that private plan. It can't be more than the 0.5%, and it can only be used for purposes of that private plan. In terms of whether your third-party payroll provider will handle that for you, I think that's a really great question to ask them, presuming they handle your other types of deductions and benefit plans. So I don't know why they wouldn't, but that's really a conversation to have directly with that third-party provider.
Yeah, and I'll say the conversations I've had with some third-party providers, they do certainly have the capability to withdraw the money and set it aside for what you need to do, much like you'd handle a 401k deduction or something like that. Or if you have supplemental insurance such as AFLAC, same concept there. Some of them also will handle it directly with the state as well and submit all the filings that need to happen. So by all means, check with your payroll provider because they probably have the solution for you. In the state of Connecticut, it's something new, but as Aaron had mentioned, other states have been doing this. So we're not the first to go through this. So definitely talk to them to see what solutions they've experienced and the best one for you.
And I did see thank you so much for that, because if you do have a payroll provider, they're most likely already withholding and planning on remitting the payments to the paid leave authority for those who don't have a private plan. And so they're on it. Talk to them, just because I like to do the belt and suspenders, but they should be on it. And as I said, we've been working with them since April to make sure that they knew what was going on.
Thank you, Erin. So we do have a few more questions revolving around private plans. So if a person submitted a private plan exemption on March 15th, if they had all required details, can it be approved for January 1 and retro effective date, or would the effective date now be July 1?
Great question. We have so many webinars, I'm not sure. I think I didn't say it in this one. If you have a private plan and it's approved by March 31st of 2021, you will be excused from remitting your 2021 quarter one payments. So you need to get your application in enough time for us to approve it before March 31st. And if you do so, you won't have to make contributions to us. We are committing that we will get applications turned around within 10 business days or less. Right now, we are trending at much, much less. But please, if you are thinking about a private plan, go to the website, check out the paperwork. You have to educate your employees about your private plan and give them at least 2 weeks to review your documentation before you hold the vote. So you really want to get started on that. And we've had several applications already submitted. There is a percentage of them where they just don't have the right documentation. They uploaded the same document twice, or they uploaded the template instead of having the actual customized plain language guide that we want you to give to your employees. So if you're interested in that, get on it now, start working toward it now. But we are committed to processing all of the applications as quickly as possible.
Okay, thank you, Erin. This one is in regards to the amount of time that would be paid for leave. Is there a predetermined amount of time that would be paid for maternity leave? Most short-term plans pay either 6 or 8 weeks.
Great question. So Connecticut Fmla, Federal FMLA says 12 weeks in a 12-month period. Connecticut FMLA says 12 weeks in a 12-month period, but you may get an extra 2 weeks if you have incapacitation during pregnancy. Income replacement from the Connecticut Paid Leave Act is 12 weeks in a 12-month period, maybe 2 extra weeks for incapacitation during pregnancy. If you haven't used any of your entitlement, then you've got that full 12 weeks available to you. Part of that time is going to be, if you're the individual who gave birth to the baby, part of that time is usually called the pregnancy disability period. And that is sort of that period of time where you're recovering from the physical act of giving birth. That's why most short-term and long-term, short-term disability says it's only 6 weeks, 8 if it's a C-section. With both FMLA and the Connecticut Paid Leave Act, we don't really get into that because you can also use time for bonding. And so if your maternity leave is both time to recover and to bond with the baby, you've got that 12 weeks. If you had a difficult pregnancy and you got incapacitation during the pregnancy part, those first 2 weeks will be treated as the extra 2, and then you get additional time. So it's not as short as short-term disability. It is capped at the maximum of the 12 or 14 weeks. And we get medical documentation from your doctor to certify that you are pregnant. And if you need the extra 2 weeks, we get certification for that.
Okay.
Probably too
My
complicated of
last
an answer,
question.
but it's sort of a complicated subject.
I know.
This particular person has an EIN and has been in business for 17 years. They're asking, isn't that my registration number with ct.gov? And I know there's the new portion of the portal that they're going to be moving. Could you touch base on that again real quick on the different registration numbers?
Okay. So it's not about your EIN, it's about credentialing. So you go to business.ct.gov, and that gives you credentials to be able to access state agency websites. It's relatively new. It just went launched last August, and not every agency is on business.ct.gov yet. Department of Revenue Services and Department of Labor in particular are not yet coordinated with this one-stop business portal. They will be, but they're not there yet. So we will be using your EIN as your unique identifier, and that helps us track who you are. But in order to get the credentials and to set yourself up in the system, you need to go to business.ct.gov, get your credentials, and then you come in to us and you'll set up your account. And then we'll use your EIN number to sort of, anytime we need to figure out who you are, we'll be using that as your number.
Okay. Okay, and the reason that question had been asked as a follow-up.
You're new. I'm sorry, I'm just jumping in here. I see that you said that you went to business.ct.gov and they think you're new. They're new. So from their perspective, everybody's new. Because if you haven't joined them yet, they don't have you in the system. It's okay. They'll get there. It'll be wonderful once we're all in. It's a long-term process.
All right, and that concludes all of our questions at the moment. I just want to say thank you to everybody. I'm going to turn this over to Richard and Aaron in just a moment, but I just wanted to let everybody know I have dropped some help links in the chat, our website, and I'm also going to include our calendar of events where you can find more webinar opportunities and our YouTube link. So if you're interested in learning more about private plans or perspectives of how paid leave applies to your business, we do have pre-recorded webinars on our YouTube page. So just be looking out in the chat for those. Thank you. Richard, I'm going to turn this over to you.
Yeah, I just want to say thank you to you, Aaron, and certainly Amber for helping me set this up. I appreciate the time and, sharing the knowledge of this important program that Connecticut's put in place. It's relevant from the perspective of what we as employers have to do, and certainly is beneficial to our employees themselves. So thank you again for the information. I appreciate your time.
Thank you so much for having us. Have a good afternoon, everyone.
Thank you. You as well.